Lords, in approaching this one,
5 years.
order was passed in 2018. Please, I'll take. Please.
Lord, in this, the respondent.
I'm there.
My lord, in this, the respondents herein had filed an application for return of
LCR.
trial court records. Since there was a direction to withdraw pursuant to the order, my lord, they have filed an application.
But the amount is deposited.
Yes, yes.
Amount is deposited. Please. Please.
Please.
Well, in connected matters, 1 week time may be granted to comply the office instructions.
Yes.
Please.
Allah, that already there is a order for release. Yes.
Please mobilize.
But in this case, it's
Kannada
also
dispensation translation. Please.
Respondents. SL. Oh.
this is
Dispensation of Kannada translation, my lord. I filed an IA for dispensation. Please. In this case, my lord,
against the mandate of section 19(7) subclass 7, mandamus was issued to issue the final notification. 19(7) 19 subclass 7 says if the final notification is not passed within 1 year, it is automatically rescinded, lapsed. So against the mandate of 19(7), learned single judge issued the mandamus to the state to issue the final notification. So therefore, we are filing the appeal on this matter. They have 2 weeks time. Against this, we are acted. Today is meeting. This is there's a
order is on 14
2024.
February 2024.
Please.
Much.
Complaint, my lord. The learned single judge order on the page number 58, my lord. 58. In the page number 59, there is order portion. In this case, my lord, that totally 1,500 square feet land has been acquired by the railway authorities, and out of that 1,200 square feet they have already utilized and they have already acquired the land, and remaining
Consider the representation ಅಂತೀವಿ.
Yes, joint survey has been conducted, my lord.
ಮಾಡಿದೆಯಾ?
ಮಾಡಿದ್ದಾರೆ ಅವರು ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಮಿಲಾಡ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಅಂತ
ಏನ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್?
that 300 square feet of the land.
ಅದನ್ನ ಆನ್ ಮಾಡಿಕೊಳ್ಳಿ ನಿಮ್ಮ ಇದನ್ನ.
Under the joint survey, my lord, with respect to these 300 square feet land is concerned, ಅದು acquire ಆಗಿಲ್ಲ ಅಂತ my lord, they submitted a report. ಅದನ್ನ ಕೊಡ್ತಾರೆ my lord. I will get.
ಕೊಡಿ. ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಆಗಿರುತ್ತೆ. ಎಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿಲ್ವಾ?
ಇಲ್ಲ ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
One submission. It is a totally different case, my lord. In the middle of the railway track, in the 30 meter from the either side, both the sides, it is a restricted area. Our 300 square feet is coming under that restricted area. We have not utilized that. It is a NA converted lands. I am saying that, my lord, making a representation before the authority, my lord, that 300 square feet, you have not given permission to construct any building, and it is totally useless building. That is useless land. There is a judgment of the Honorable Apex Court. It is mentioned in the High Court, in the judgment also, my lord. It is clearly stated that there is a circular by the authorities.
ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಇದೆ.
ಹೌದು. ಅಕ್ವೈರ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೂ ಅದ್ರ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ಬೇಕಂತಿದೆ.
ಎಕ್ವೈರ್ ಮಾಡೋದಿಲ್ಲ. ಕಾಂಪನ್ಸೇಷನ್ ಎಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡು ಹೇಳಿಕ್ ಬರಲ್ಲ.
My lord, there is no restriction as per the railway circular. There is no restriction.
ನೀವು
They
ಹಂಗೆ
can-
ಹೇಳ್ರಿ, ಬರೆದು ಹಾಕ್ತಿವಿ.
Yes, my lord.
ಅವ್ರ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಇಲ್ಲ, ಅದು
ಅದು circular is-
ಕಟ್ಟಿದಂಗೆ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿಗೆಬಹುದು ಅನ್ಕೊಂಡು ನಾವು ಬರೆದು ಹಾಕ್ಬಿಡ್ತೀವಿ.
In fact, in the Supreme Court judgment itself.
Lord, there is a
it mentioned.
judgment, my lord.
I'll submit that.
They are saying no restriction. We'll record it. Put up construction.
Please,
But don't obstruct the movement of the railway.
Please.
Only thing is, only thing,
Actually, my lord, what happened within the restricted area, my lord, even though I have constructed any building,
only thing
Is
is.
a-
He is saying that we have no objection for putting up any construction. There is no restriction ಅಂತ ಹೇಳ್ತೇವೆ.
Only NOC has to
if
take.
they
my
are
lord, NOC
giving
has
a
to take-
endorsement that it is not a within a restricted area, my lord, I am,
ಮುಗಿದು ಹೋಯ್ತು.
please.
ಬರ್ಕೊಳ್ಳಿ. This complaint alleges violation of a learned single judge and
Single judge.
Lord, single.
a learned single judge's order dated 24 January 2024. Kindly be seated.
Please.
Whereby complainants WP number 107926 of 2023 LA arrest came to be disposed of. First, para 5 of the order whose violation is complained of reads as under page 5960 ದಲ್ಲಿ ಇದೆ, ಇದೆಲ್ಲ ಹಾಕಿದ್ದೀನಿ. Next. Learned panel counsel appearing for the railways and learned GA appearing for the, ಎಲ್ಲೇ ಹೋಗಿ ನೀವು appear ಆಗ್ತೀರಾ?
His role is only to
Submit that the petition, the mandate of the learned single judge has been accomplished, and that the area in respect of which the complainant alleges that there is a restrictive enjoyment, is free from any restriction, is the submission of
Only they have to take NOC. Andre, they should not block our way ಅಂತ ಅಷ್ಟೇ. That is the NOC.
all, says the panel counsel. First, he hastens to add that though there is no restriction whatsoever for undertaking any construction activity in the said area, as a matter of formality, NOC has to be obtained from the jurisdictional authority. First, next paragraph. In view of the above stand of the respondents, answering respondents, these proceedings are liable to be and accordingly dropped.
Please.
Okay.
Lord, they have not issued any endorsement for that.
Endorsement ಬೇಕಾದ್ರೆ
ಅಲ್ಲ, ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಯಾವ ಎಂಡೋರ್ಸ್ಮೆಂಟ್? ಈ ಸ್ಟ್ಯಾಂಡ್ ಬರ್ದ್ಬಿಟ್ಟು ಕೊಡಿ, ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Endorsement.
ಕೊಡಿ.
I also receive.
Please.
ಮುಗಿದೋಯ್ತು. ನೀವು ಎಂಟೈರ್ ಏರಿಯಾ ಫ್ರೀ ನಾವು ಬರ್ದು ಹಾಕ್ಬಿಟ್ವಿ ನಾವು.
Lord,
No
without
restriction ಅಂತ.
Lord, without endorsement, my lord, that is within a restricted area, Honorable Supreme Court says that they have to pay the compensation for that.
ಅಲ್ರಿ ಅವ್ರ ಸ್ಟ್ಯಾಂಡ್ ಇದೆಯಪ್ಪ, ನಾವೇನು ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಇಲ್ಲ ಏರಿಯಾದಲ್ಲಿ ಅಂತ.
Let them issue
ಕೊಟ್ಬಿಡಿ.
let them issue an
Circular is,
endorsement.
the Honorable Supreme Court has made a part of the judgment, paragraph 12. Circular number ಎಲ್ಲ ಬರ್ದಿದ್ದಾರೆ. What is that?
ನಮ್ಗದು ಗೊತ್ತಿಲ್ಲ, ಈಗ ನಿಮ್ ಸ್ಟ್ಯಾಂಡ್ ಅನ್ನು ಬರ್ದೇವೆ
Yes,
ನಾವು.
Lord, yes.
ಬಿಡಿ
Lord,
ಅವ್ರಿಗೆ ನಾಳೆ ಕಿರಿಕಿರಿ ಮಾಡಂಗಿಲ್ಲ ಅಷ್ಟೇ.
Lord, let them issue an endorsement.
ಕೊಡಿ ಕೊಡಿ, ಕಾಪಿ ಕೊಡಿ,
Yes, my lord.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕಾಪಿ ಕೊಡಿ. ಅಲ್ಲ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನೀವು ಚಾಲೆಂಜ್ ಏನ ಮಾಡೋದಿದೆಯೇನೋ? ಲಿಬರ್ಟಿ ಇಸ್ ರಿಸರ್ವ್ಡ್
Please.
to the complainant to seek redressal against the endorsement dated. Date
ಇಲ್ಲ,
ಏನದು?
ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ, endorsement ಕೊಟ್ಟಿಲ್ಲ.
ಹೌದು,
Extended
ಡೇಟ್ ಹೇಳಿ, ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನಿಮ್ಮ ಮತ್ತಿಗೆ ಇರೋದು.
ಇಲ್ಲ,
report
ಎಲ್ಲ
ಆಗಿ- report ಆಗಿದೆ.
Endorsement in the making.
Please, please.
First, a copy of the endorsement after it's being made shall be shared with the complainant without broking any delay. First, delay if broke will be viewed very seriously and thousands of rupees cost may be imposed on the hearing official. Okay.
Please.
ಇದು ಇದೇ ರೀತಿ ಇನ್ಮೇಲೆ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ನಮ್ಮ ಸಭ್ಯವಾಗಿ ಬರೆಯೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಡ್ಯಾಗರ್ ಹಿಡ್ಕೊಂಡೇ ನಿಂತ್ಕೋಬೇಕೆಲ್ಲ ಜಡ್ಜ್ಗಳು, ಹಂಗಾಗಿದೆ.
Here for the appellant, your lordship.
Irma?
Survives petition challenging the divorce order. Please take,
You would have filed there only, no?
please.
You would have moved before the family court only.
Since expiry order has been passed, Your Lordship.
9:13.
Please.
ಹೌದು.
Please, sir. Advocate B.S. Patil has.
ಈಗ ಮ್ಯಾರೇಜ್ ಮಾಡ್ಕೊತಾ ಇದಾರನ ಅವರು?
Now he is likely to get second marriage.
ಅಷ್ಟು ಅವಸರ ಮಾಡ್ಕೊಂಡು ಮೊದ್ಲೇ ಕಳ್ಕೊಂಡು
There is a 3.5 years son.
ಸರ್ವಿಸ್ ಆಗಿದೆ ಏನು?
Please.
ಆಗಿದೆ.
Delay of 649 days in putting the police control. Matter requires consideration. Hence, there shall be interim order of stay of the impugned judgment and decree of the family court. Further, the respondent is restrained from contacting second marriage. This appeal. Set aside ಮಾಡಿ expert sir, ಅಲ್ಲೇ ಕಳ್ಸೋದಿದೆ.
Please.
ಕರ್ಕೊಂಬನ್ನಿ, ಅಲ್ಲಿ set aside ಮಾಡಿ ಕಳಿಸ್ಬಿಡ.
Great.
appeal by the Niravari.
New law.
Yes, my lord, new act, my lord.
At least along with that.
ನೋಟಿಸ್ ತೊಳಿ.
This one. For response number 1 for HCCP, my lord. 1 and 3, my lord.
Third, reserved, list along with.
ಅಮೆಂಡ್ಮೆಂಟ್ ಜೊತೆ ಹಾಕಿ. ನೀರಾವರಿ ನಿಗಮ.
My lord, I sought for stay, my lord. The execution is.
The judgment is we are drafting, framing that judgment.
ಇದು 1200 ದಿವಸ ಡಿಲೇ. 1200 ದಿವಸ
ಅಲ್ಲಿ 120 10 times ಮಾಡ್ಯಾರ ಅವರು.
100 times ಅಲ್ಲಿ.
ಹಂಗಾಗಿ. Reserved ಇದೆ ಅವ್ರ ಜೊತೆ.
Claimant appeal, my lord, for enhancement of amount. Notice. Shri Ram Chandra.
Subhash J. Patti, emergent notice to R1 on IA 1 of 24 as well as.
Please.
Expand to the link. Emergent notice, IA 1 of 24 as well as made. Meanwhile, there shall be interim order of stay of the impugned judgment and award of the tribunals.
Subject to.
Appellant depositing entire compensation amount along with the interest before the tribunal within a period of 8 weeks. The tribunal is directed to redeposit the same in any nationalized bank, interest bearing account. The medical renewal class.
This appeal, my lord, I have filed a memo for retirement, my lord, and already wakalat has been filed, my lord, by Sri H.N.M. Prasad.
ಯಾರು ವಕಾಲತ್ ಹಾಕಿದ?
My lord, H.N. Manjunath Prasad.
Nilo Panti is permitted to retire from the case. ಯಾರಿದ್ದಾರೆ? ಪ್ರಸಾದ್ ಎಲ್ಲಿದ್ದಾರೆ?
He is from Bangalore, my lord.
ಬೆಂಗಳೂರು.
Lord, sir, praise the week's time he is suffering from, Lord, sir.
Immediate application. On request. ಇಲ್ಲಿ ನೀರೋ ಪಂತ್ ಇದ್ದಾರೆ, ಎಲ್ಲ ಕಡೆ ತೆಗಿತಾರೆ.
Please, my lordship. I filed a IF for dispensation for translation copy of the Kannada.
31. Notice. 31. Yes, Prashant.
The site abutting to me has been declared as a road in master plan. Site, the abutting to the eastern side of my property, there existed a road. Kindly see page 85, master plan, annexure G.
$85.
This is the master plan.
Triangle type ಏನೋ ಒಂದು ಮಾಡಿರಲ್ಲ, plus on the round.
On the left side of that, my property is situated. This has been approved by the government wide order number so and so, dated 15/2/2014,
And after making this road, my lord, there was certain, the entire, the property was vacant. Then I requested the municipal corporation to make a road, my lord. Then they ignored it and I filed a writ petition before this.
To make the road.
Yes, my lord. And then the direction was given and still they did not do it. Then I filed a contempt petition. When the contempt proceeding was pending, my lord, then the impugned order came to be passed, saying the resolution came to be passed by the Urban Development Authority, stating that by mistake this has been crept in. There did not exist a road, it has been by mistake, it has been crept in. If that was a mistake, my lord, this particular master plan has been approved by the government. And if there is any change in the master plan, then they have to pass through section 14A of there are judgments of the.
Rectification order ಮಾಡಬೇಕಾ?
Yes, my lord, because again it has to go to the government. And then unless there are judgments of this Honorable Apex Court and in the Vinayak House Building Cooperative Society, my lord, unless they invoke section 14A, there can't be any changes in the master plan, which is already approved by the government. That's the only issue.
ಎಲ್ಲರೂ single judge ಏನಂತಾರೆ?
Then a single judge, they say that in earlier master plan, there existed a site which has already been approved by the Urban Development Authority. Hence, there was a mistake and that can be corrected by virtue of a resolution.
ನಿಮ್ಗೆ ಕೊಟ್ಟಂತ ಲೇಔಟ್ ಪ್ಲಾನ್ ದಲ್ಲಿ ರೋಡ್ ಇಲ್ಲ.
Road
ಮಿಸ್ಟೇಕ್ ಆಗಿ ಬಂದಿದೆ.
Mistake agide antar, but mistake, can this such mistake be approved by the government, my lord? Because it is, whenever a master plan has been prepared, my lord, there is earlier it was the concept of ODP and CDP, which came to be amended.
My lord, at page 26, internal, 26, my lord.
ಬೈ ಮಿಸ್ಟೇಕ್ ಕಲರ್ ಹೊಡೆದ್ರಲ್ಲಿ ಒಂದು ಬಿಸ್ನೆಸ್ ಇರುತ್ತೆ. ಇದ್ರಲ್ಲಿ ಸರಿ ಅಂತ ಅಳಿಸ್ಬೇಕಂದ್ರೆ ಇರೇಸರ್ಗೂ ಒಂದು ವ್ಯವಸ್ಥೆ ಮಾಡಬೇಕು ಅಂತ.
Unless that master plan is approved by the government, it will not come into effect.
Same reverse process you have to go it and correct it.
Yes.
Otherwise it is a road. That it says no, you go by your plan.
Earlier plans,
Layout plan says something. So it is only shown that does not confer any right ಅಂತ ಹೇಳಿ. ಆಗತ್ತೆ.
Third party rights have been created now.
ಹೌದು.
No, earlier there was.
Please come to page 8, para 8, page 26.
Yes, ma'am. In the ODP, the revised CDP, there is there is no such road which has been shown, but has been only shown in RMP of the year 2021. Admittedly, there is a layout plan sanction which has been issued in respect of site number 66 on 21/12/1982, where under certain sites have been allowed to be formed. There are no certain sites, it's only one site.
One site is allotted to somebody else and he has put up construction.
The layout permission.
You can't undo it now. This reasoning appears to be sensible. He is not a party. Site owner is also not a party.
He has got implicated himself. No, site owner is a party. Site owner is a party. He has not filed
Already
any.
construction ಇದೆಯಲ್ಲ.
ಇಲ್ಲ, construction ಏನಿಲ್ಲ, it's open site. Open site.
It is allotted to somebody else.
Also allotted, they claim that it is allotted to somebody else and it was completely open site. And then when he tried to construct over that, then we inquired with the. The respond number 4 is he claims that he is the owner of that particular plot.
Allot ಆಗಿದೆ, ownership payment ಮಾಡೇನೆ, ದುಡ್ಡು ತಗೊಂಡಾಗಿದೆ, he is in possession of the property. We can't, even if there is some mistake, nothing can be done now.
Because.
Learned single judge, while denying relief to the appellant by dismissing his WP number 100723 of 2022, wide impugned order, has observed as under. First, we are in agreement with the same. Therefore, appeal is dismissed.
For R1, I accept.
Pending a appeal into insignificance.
For R1, I accept notice. R1 ಗೆ accept.
Appears for R1. We can't do it this length of time. Yes.
I'm for the appellant matters. It pertains to the selection of Anganwadi Karyakarta matters. And earlier she was selected to the said post as per Annexure M. And later on, somebody have objected and her appointment was cancelled, and notices were issued. Selection was appointed to the,
You are not resident of that place.
no, it's a
The
hamlet.
voters
Madam.
list ಏನಂತೆ?
No, it is a hamlet.
Huh?
It is a hamlet.
Hamlet. Voters list ನಲ್ಲಿ ಏನಂತೆ?
Yes, my lords, I have produced everything. Shattlegary village is the main village, and to that effect, annexure M may kindly be seen, my lords, at ink page number 49.
ಶಡುಲ್ಗೇರಿ ವಿಲೇಜ್ ನಲ್ಲಿ ಅದರ electoral roll ನಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರು ಇದೆ.
ಇದೆ, my lords.
ಇದೆ.
Yes.
Electoral rolls are prepared under the
Even in Aadhaar
election
card.
registration rules 1966.
Yes.
There is a big process.
Yes.
ಆ process ಪ್ರಕಾರ ನಿಮ್ಮಲ್ಲಿದೆ. When in Manmohan Singh versus so and so, the apex court said under section 20, if a person is ordinarily 20 of Representation of People Act,
Yes.
if a person is an ordinary resident of that area, he gets the name entered into that one.
Yes.
And therefore, he has said, learned single judge has given para 3.
Yes, sir. That's the only ground, my lords. Since she is married and her name has been deleted from the survey records, she is not the resident of that village. If we go through
After marriage, where the lady will go in our
No,
society?
if we go through annexure N, my lords, Shattlegary village is the main village of this M must be Kurbanala village. Annexure M, ink page number 49.
Anyway, after marriage, you have joined the matrimonial home.
She was along with her parents and her husband. She was residing in the parental house itself.
After marriage?
Even after marriage.
So no, there is the pleading.
It is the,
Show the pleading.
yes, my lords.
There is a strong presumption
Yes.
which a famous author, Duncan or Derrett, a famous author whom Supreme Court has referred to on Indian law of marriage and divorce, Duncan Derrett on the Google, that's one judgment of the apex court. ಅವನು ಹೇಳೋದೇನು ಅಂದ್ರೆ, after marriage in India, in the Asian countries, women follow the footsteps of husband. And matrimonial home is the home which the husband establishes ordinarily, subject to all just exceptions. For example, she is employed, she is doing some job, not in a position to move, except in Aliya Santana law.
Yes.
In Aliya Santana law, the son-in-law will go to the house of the father-in-law and stay there, and there is a separate law for that. But in respect of other things,
Yes.
she follows the footsteps like Sita followed Rama wherever Rama went. Of course, Lakshmana's wife,
Urmila.
Urmila,
Yes.
except that she stayed because Rama did not permit.
Yes.
There is some logic. But learned single judge, while denying relief to the appellant by dismissing his WP number 79898 of 2013, has given the reason at para 3 of the impugned judgment, which reads as under. First, next paragraph. It has been a long settled position of conventional law in the country that ordinarily the wife joins the matrimonial home of the husband. First off, this the entry in the electoral rolls pertaining to Shadulagiri village, SHADULGA, pertaining to the village in question, reflects the same thing. First off, the entries in the electoral rolls are made in a normative process enacted in the registration of electoral rules 1966. So and so. First, a presumption arises as to their validity. First, next paragraph. I'll say this one. All this animates the impugned judgment of the learned single judge. First, in view of the above, appeal is liable to be and accordingly rejected. ನೀವು ಯಾರ ಪಾರ್ಟಿ ಇದ್ರೇನ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. ನೆಕ್ಸ್ಟ್ ಜಡ್ಮೆಂಟ್ ತೆಗಿಬೇಕು. ಯಾವ್ದು ರಾಮ್ ಜೇಠ್ಮಲಾನಿ ವರ್ಸಸ್ AK ಸುಬ್ಬಯ್ಯ, ಯಾವ್ದು ಅದನ್ನ ತೆಗೆದುಕೊಡ್ಬೇಕು.
Please, Malord.
Yes.
Malords, appellants
Yes.
are the elected directors of respond number 5 society. Election was held to the respond number 5 society
One kind
on
submission.
20th August 2023.
Kind permission. Serial number 17, where the contempt petition was filed, the lordships was pleased to observe and dismiss with arising out of the same interim order. Parallel proceedings arising out between the same parties. They are same.
Society is same, but
Societies and the parties are
now
same.
also I came, just now I came.
No
to-
contempt ಇಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ವಿ ಅಷ್ಟೇ. No contempt ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ವಿ.
The election was held on 20th August 2023, my lords. Appellants were the elected members of the board of respond number 5 society. My lord, respond number 2, who lost the election, filed an election dispute before respondent number 1. And respond number 1 allowed the election dispute and set aside the election of the respond number 5 society.
When election was held?
On 20th August 2023.
28 2023. That was put in challenge.
That was put in challenge.
In section 70, 71 another.
Under section 70.
70 challenge.
72C.
Section 72C.
My lord, the election petition filed before respond number 1.
What happened to that? Idu EP and idu 72C.
Yes.
EP number?
Two petitions were filed. This is
Page
DRN
34.
DDS DRN bar F
Number
bar DDS 439
EP 439.
bar 2023-24.
This was filed by your client.
No, no. Respond number 2.
You were the return candidates, Sanali.
We are return candidates. My lord, election came to be set aside on a technical ground by respond number 1.
Respond number 1 is that
DRCS.
DRCS.
DRCS. Deputy Registrar. My lord, this order was passed on 24/5/2024.
It was set aside when?
Respond number 1.
Allowed on?
24.
ಅದು ಆರ್ಡರ್ ಅನ್ಬೇಕು ಅವಾರ್ಡ್ ಅನ್ಬೇಕು ಏನ್ ಅನ್ಬೇಕು ರವಿಶಂಕರ್?
But in respect of an election dispute, it will be an award only, my lords. 72C. 71 disputes are awards, sir. 72C will be orders only.
Order. Order dated?
24/5/2024.
24/5/24.
My lord, this order
Election
was,
is set aside.
election is set aside.
ಅದನ್ನ re-election ಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರ ಅಥವಾ ಏನು ಅದು?
Election was set aside and election is to be held to the respond number 5 society within 6 months from the
period. Election set aside with direction to hold it afresh.
Hold fresh elections. My lord, this order of DRCS was passed in mysterious circumstances, my lord. This order was not pronounced in the open court at all. From 22nd May to 24 May 2024, he was not at all in the office. Order was not pronounced, but the order was passed by the respond number 1 in sitting in unknown place, and it was transmitted through mobile phone. And Deputy Commissioner conducted an inquiry and submitted a report to the government that without sitting in the office, he has pronounced an order. And annexure C, my lord.
Where is that?
This is the order of the government based on the report of the
Where is that?
annexure C,
Page number?
page 54.
54.
54 is the order of the government considering the report of the Deputy Commissioner. This DRCS was placed under suspension.
For that reason only?
Yes, for that reason only. Page 54, my lords. May I read, my lord? Second paragraph of the first page, 54.
think they will do.
Para 2.
Judicial review. ಮುಂದೇನಾಯ್ತು?
My lord, we preferred appeal under section 105. 105 of the
appeal
Public
came
Society
to
Act to the Karnataka Appellate Tribunal.
What happened to appeal?
Appeal is pending.
Still pending.
Appeal is pending. At I number 1, we sought for stay of
That
the
order that was not given.
set aside election.
So you went to learned single judge.
Yes,
That is also rejected.
that is also rejected. My lord,
Lord, single judge is not rejected, my lord, so it's only deferred.
not rejected, my lord, deferred. Deferred to consider the, my lord.
ಏನು ಮುಂದೇನಿದೆ ನಿಮ್ದು ಆಯ್ತು. So learned single judge ಏನು ಹೇಳಿದ್ರು? He did not give the stay.
No, he did not give the say. He deferred to consider the grant of interim order. My lord,
KAT.
another relevant submission, my lord.
KAT reject, please.
Before KAT, my lord. Yes.
Or you argue whatever you argue, we will hear you.
I'm sorry.
Or you want to satisfy the judges?
I'm sorry.
ಮತ್ತೆ? Why KAT rejected your application?
My lord,
Come to that.
Lordship may kindly turn to annexure K, page number 130.
130.
130. Para 9, point number 3, finding given to point number 3. In so far as this point is concerned.
1 second, we'll read it.
Society.
Who appears for the respondent?
In the connected read.
In this, my lord, no,
I'm appealing for the respondent in this matter, my lords.
In this, Ravi Shankar is appearing for. Yes. Tell.
33.1.
How kindly come to 130?
Lords, kindly, Lords, may kindly have a look at page 120, my lords, because what was read was point number 2, which only considered the irreparable injury. Lords, there are 3 parts for consideration of an interim prayer. Prima facie case and balance of convenience is point numbers 1 and 2.
Page number?
Page number 120, bottom of the page.
120.
Yes. So now if your lordships were to see, my lord, there is a detailed discussion regarding point number 1 and 2. May I draw your lordships' attention to page number 122, paragraph number 8.2, which records the contentions, and para 8.8, finding is given at page 125. Prima facie observations, my lords, ultimately. But the findings which he is reading is only whether there is a irreparable injury. In view of the aforestated observations of the lordships of the Honorable Apex Court as well as the Honorable High Court, under the provisions of 13D2A of the Karnataka Cooperative Societies Act is mandatory provision to be followed during the course of conduct of election to a cooperative society. Non-following of the said provision would give rise to a cause to challenge the election. If such a procedure has not been followed, of course, it is a question to be considered at the time of final disposal. Further fact, the second respondent is a member of the fifth respondent society is concerned. There is no serious dispute. Such being the case, in our opinion, impugned order of the first respondent cannot be stayed at this stage. Notice a prima facie finding is recorded on the factual aspects. Notice the irreparable injury, what he is read at page number 130 is regarding irreparable injury. So, in order to ensure that the appeal is expedited, an observation is made saying that since there is no election in the annual immediately, this could be done. The matter could be heard. Now, when he goes before the learned single judge, if your lordships were to see page number 17, my lords.
Rule 13. No, DRCS has set aside on order ground consideration.
My lords, JRCS order, my lords, if your lordships were to, my lords, the
DRCS.
elections, when it is set aside, there is no board in existence. When the board is not in existence under section 31(1) of the Karnataka Cooperative Societies Act, a special officer is to be appointed, who in turn will have to conduct the elections afresh. Page 7, I'm sorry.
Administrative affairs society ನಡೀತಾ ಇದೆ.
No, it's page 7.
ಇನ್ನೊಂದು ರಿಟ್ ಅಪೀಲ್ ಏನದು? ಕಂಪೇನಿಯನ್ ಮ್ಯಾಟರ್ ಏನದು?
33.1.
ಹಾ.
Same. Two persons had preferred election dispute. So two, both cases were clubbed and common order was passed
DRCS.
By DRCS.
Yes, under section 72C ಕೆಳಗಡೆ.
But technically we had to prefer two appeals. And two.
Writ petition, they could have preferred a single writ appeal because it was a common order passed. Lords, page 17, if your lords were to see, Lords, the learned single judge has only said that the interim prayer will be considered.
See, we will not say more than that, but it's pending. The deputy commissioner has sent the report. Officer is kept under suspension on the misconduct. Still, there is no for interim order.
Lords, I may just clarify this issue, my lords. Lords, so far as this issue is concerned, if whether the deputy commissioner's order, whether there was a requirement of pronouncement of the orders in the open court was specifically argued before the tribunal, before the Karnataka Administrative Tribunal. Lords, there is no requirement, my lords, for pronouncing the orders in the open court.
Section 116 of Cooperative Societies Act mandates.
Why can't you sit down, please?
Please, sorry, ma'am.
Or you want to disturb? He is arguing. Why? What kind of culture? I do not know. Avdalla ಆದ್ಮೇಲೆ ನೀವು ಹೇಳಿ. Yes.
Lords, now, so far as the orders of the report of the government or the deputy commissioner is concerned, would not overturn the factual aspects which has been, for which a finding has been given. Lords, the factual finding which has been given for the purpose of overturning the election is that the elections are conducted without compliance with the procedure for finalizing the voters list.
Rule 13 is not followed.
That is not followed. Lords, factually, this is not disputed. Lords, what happens? There is an explanation. Lords, if your lords were to consider this issue, lords, at this stage, this is an issue which can as well be lords, urged before the learned single judge. Absolutely no difficulty. Now, if this is an answer, because we have not yet filed our objections before the learned single judge.
We are also on the process of handling that.
We have not yet filed our objections before the learned single judge yet. Lords, if we were to file our objections regarding whatever has been stated regarding that the deputy commissioner's order, further proceedings have already been undertaken. His suspension has been recalled because he has given an explanation, my lords, as to why the orders was passed. It is not that he was not in station, which is not a correct statement. There are subsequent proceedings. Now your lordships is only referring to this. If an opportunity to file the objections is given, my lords, either before your lordships or before the single judge, we'll place it before your lordships.
Having admit issue, admit interim order for ABCD reasons. Yes.
Please.
Next. Come on. Next. Notice, emergency notice. Private party no vehicle. Yes,
Please. Similar matters yesterday, the lordships was pleased to issue notice since there was a delay.
3F 24 as well as on me.
Please. This matter wherein, my lord, as the lordships with regarding to section 95 sub clause 2 proviso, other matter. That 14, if that master plan comes under within the area of the master plan, then invoking section 14A of the act, my lord, unless and until the competent authority decides, the deputy commissioner has no right to seek for conversion of that land.
ಅದರ ಜೊತೆ ಕಾಲ್ ಮಾಡಕ to be called along with that matter.
Yes, ಅಲ್ಲ ಇದು ಬೇಡ, ಇದು ಹೇಳ್ತಲ್ಲ ನೋಟಿಸ್ ಶಲ್ ಬಿ ಗೋನ್, ಯಾಕಂದ್ರೆ ಅದಕ್ಕೆ ಬೇರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಅದಾವ.
Notice on I as well, same order.
Same order.
Case as well as me.
55 ಅಲ್ವಾ? ಶೀಲ್ವಂತ್.
35 minutes. I've been instructed to appear on behalf of the respondents, my lords.
Respondent.
Respondents.
Yeah.
On this.
These petitioners were appointed as employees.
I'll file my power. my lords.
Mrityunjay.
Sure.
Mrityunjay.
Hold. Obliged.
Mr. PP Hegde is online, my lord.
Yes.
Well, at senior counsel, Mr. PP Hegde appears in the matter. I was told that he was online, but it appears he is not there. May I seek a passover, my lord? PP Hegde ಅವ್ರಿಗೆ engage ಮಾಡಿದ್ದಾರೆ.
ಮೃತ್ಯುಂಜಯ. ಅದೇನು ಹೇಳಿ. You treat your senior advocate only.
He is
You are
briefed and
senior advocate of our court.
he is briefed and he was there, my
Lot
lord.
of preparation.
I'm present.
Yes.
Please, I was not allowed earlier. Now I'm allowed. Please.
ಇಲ್ಲ ಇಲ್ಲ ಇದೆ
Please.
Good candidate.
May it please, my lords.
Judges. It is very, comes with lot of preparation, very appreciable. Girish, CG, ಚೆನ್ನಾಗಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Now, yes. Yes, Mr. Hegde.
Please. I'm sorry, my lord, could not join immediately because I was not permitted earlier.
Yes.
My lord, this is a case where in the disciplinary inquiry, he is held guilty and his punishment is awarded. Facts are that he was the assistant commissioner of the sales tax, my lords, and the accused number, he is accused number 1. Accused number 2 received certain amount, is a chartered accountant. In the full-fledged trial before the sessions court, he is exonerated, holding not guilty.
Exonerated or acquitted? What are you speaking?
Sorry, he is acquitted.
What is your wrong terminology?
Yes, I do confess, my lord, confess. My lord, he was acquitted after the full-fledged trial. That's at operative portion of the judgment of the session judge is at 156. Now, my lord, in the sessions trial, page 157, there are 10 witnesses examined and as many as 48 exhibits marked. As far as the disciplinary inquiry is concerned, there are only 3 witnesses examined. One is the complainant, number 2 is the shadow witness, and investigating officer. Charge is identical. Therein he is held guilty, and the punishment is imposed. And that finding of the inquiry officer resulting in the punishment is impugned before this honorable court. My main submission is, my lords, once the criminal court holds not guilty after full-fledged trial, can the finding of the disciplinary inquiry continue? I beg to submit with kind permission the recent view of the honorable Supreme Court by the law on this point. That's in Ramlaw 2024, my lords. My learned friend.
Ramlal is referred to in PV Rudrappa. Law has again marched further.
Given a judgment to.
You are a bit older now. Go to PV Rudrappa.
Please.
PV Rudrappa ನೋಡ್ಕೊಂಬರ್ತೀರಾ?
Please, my lord, this is Rudra, PV Rudrappa. I beg to submit this also.
PV Rudrappa versus state.
Please, I will look into this, but I will rely upon only one para now, my lords, for presently. Only one para, one sentence I rely upon, my lords, in Ramlal 2024.
Ramlal is considered by us, PV Rudrappa.
Please.
Therefore, read and come back.
Please, may I submit, my lords, your lords may kindly notify also, my lords, be pleased to order the notice to others also, my lords.
ನಮ್ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ಆಮೇಲೆ ಮಾಡಂತ
Please, please.
ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅವ್ರಿಗೆ ಪಿ ವಿ ರುದ್ರಪ್ಪ ಜಡ್ಜ್ಮೆಂಟ್ ಶೇರ್ ಮಾಡಿ.
Let's.
Yes.
My lord, the main petition is the other one.
101461.
Yes, my lord. Wherein Lokayukta has challenged the order of the KAT, Belgavi. My lord, this has been pending for long.
Start.
Yeah. My lord, I am the original complainant before the Lokayukta. On 30/3/2012, I was traveling on my bike towards my residence in KR-Puram, Bangalore. The DGO, that is Basavanna, stopped me and he tested me for the alcohol content in the alcometer. The alcometer was not working. He demanded my documents. I gave all the documents which were under my bike. And immediately he started, he demanded 2,000 rupees. He got another alcometer, which initially it was not giving a reading. Thereafter, he brought another alcometer, which gave a reading of 41. 40% is the minimum for prosecuting a person under DUI.
Which is that section which permits drinks even when one wants to drive? Which is that section in the Motor Vehicles Act ಇದೆಯಲ್ಲ? Drinks ಮಾಡಿ ಡ್ರೈವ್ ಮಾಡಬಹುದು ಅಂತ ಒಂದು ಸೆಕ್ಷನ್ ಇದೆಯಲ್ರಿ? ಯಾವುದು ಸೆಕ್ಷನ್?
187 says, my lords,
180?
187, my lords, wherein, my lord, the.
My lord, it is recorded in the.
ನಾವು ಲಾ ಗೊತ್ತು ಮಾಡ್ತೀವಿ, ಬೇರೆ ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ? Driving when mentally or physically unfit to drive. Whoever drives a motor vehicle in any public place when he is knowledge suffering from any disease. ಯಾವ ಸೆಕ್ಷನ್ ಅದು? ವಿಚ್ ಅಲೋಸ್ ಡ್ರಿಂಕ್ಸ್ ಅಪ್ ಟು ಪರ್ಟಿಕ್ಯುಲರ್ ಲಿಮಿಟ್? ಯಾವ್ದೋ ಸೆಕ್ಷನ್ ಇದೆಯಲ್ಲ? 180?
185 says, 185, my lords, he is booked with 185.
185.
Consumption of, my lord, alcohol.
Driving by a drunken person or person the influence of drugs. Whoever while driving or attempting to drive a motor vehicle has in his blood alcohol exceeding 30 mg ಇದ್ರೆ ಮಾತ್ರ prohibited per 100 ml of blood. ಅದು within ಅಷ್ಟಿತ್ತು ಅಂದ್ರೆ he can drive even after taking the drinks. ನಾನೊಂದು ಎರಡು ಫೇಮಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ತೆಗಿ. Section 130, 185 of the Motor Vehicles Act.
My lord, 30%, which is amended by Karnataka Act to 40%.
So you can consume more and you can drive. Law is that way.
Yes. My lord, he demanded 2,000 rupees. I was not drunk or driving.
Yes.
He demanded 2,000 rupees. I did not pay. He assaulted me, causing grievous injury in my right ear. And thereafter, he demanded to sign the challan which he had generated from the alcometer. I did refuse to because it was not my reading. He brought someone else's reading. He brought all the policemen around, 7 to 10 policemen were there. They all also assaulted me. Thereafter, I filed a complaint. The police did not register FIR. There was a grievous injury. It attacks 324 of the IPC. My lord, thereafter, I filed a complaint with the police, commissioner of police. Nobody filed registered the FIR. I went to the court and filed a private complaint through an advocate. My lord, I parallelly.
What happened to that 200 complaint?
That is pending, my lord.
Still pending.
It is pending. My lord, in the meanwhile, I filed on 17.
This complaint was filed, PC was filed when?
On 5/4, private complaint on 17/4/2000.
He was convicted for the, my lords, drink and drive, my lords. Case was registered, charge sheet was filed. He was convicted, my lords.
My lord, I'll bring those facts.
One second, were you convicted?
Yes, my lord.
What happened to conviction?
My lord,
ಅದು ಕನ್ವಿಕ್ಷನ್ ಆದ್ಮೇಲೆ ಏನಾಯ್ತು ಮುಂದೆ?
My lord, I challenged the conviction and I got an acquittal. White
Acquittal
order
what?
dated. I have attached the order, judgment dated at annexure T, page number 254.
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ನಂಬರ್ ಏನದು?
Criminal appeal number 505 of 2013, which is annexed at annexure T.
Acquitted. Okay.
My lord, it was full of, a charge sheet was filed without registering FIR, without recording any statements under section 161 or.
Anyway, acquittal happened. Okay, next.
Yes, my lord.
The dated, acquittal dated?
My lord.
Date of acquittal ಏನು?
My lords, on 28/7/2021.
20 August.
28/7.
28/7/2021.
2021. All right. ಮುಂದೇನಾಯ್ತು?
My lord, parallelly, I had filed a complaint before the Honorable Lokayukta to initiate disciplinary action for misuse of power and misconduct. My lord,
left a point.
let me complete. He is not.
ಏನು ಲಾಯರ್ ಹೇಳ್ತಾರೆ ಜೋರ್ ಮಾಡಬಾರ್ದು. ನಮಗೆ ಅಡ್ರೆಸ್ ಮಾಡಬಹುದು. You can't address him. He is a member of the bar.
I am not.
Sit down. Sit down. Yes, brother, what you want to say?
Before Millard's initiation, Millard's complaint before Millard's Lokayukta, Millard's he approached the higher authority where Millard's I was working as a Millard's police inspector. Millard's he files a complaint before the Millard's the authority saying that
You want to argue on merits?
No. Because 2
he
points
has to argue first.
2 reports where Millard's inquiry was conducted. Millard's on the Millard's initiation of complaint by the Millard's the appellant hearing. And Millard's
So you are taking us to merits of the case.
No. Millard's he left Millard's he says directly he went to Lokayukta before Millard's approaching.
Thereafter you can mention, no, he is a private party, he is not a lawyer or
I'm sorry.
something. He wants to have a full say. Kutkali, please, don't disturb him. The party out, private party. But you are not supposed to threaten the lawyer that way.
My lord, I address the court. My lord.
ನಮಗೆ ಹೇಳಿ, ಅವ್ರಿಗೆ ಯಾಕೆ ಹೇಳ್ತೀರಿ? Yes.
My lord, parallelly, I filed a complaint before Honorable Lokayukta. The Honorable Lokayukta passed an order, 12/12/2020, 2014.
Others need not wait. Come after lunch. We have another chamber matter. Okay, therefore, you need not wait.
Fast, sir, you should be fast.
My lord,
Please be fast, little fast.
yeah. My lord, there was 12/3 report sent to the government, and the government entrusted the inquiry, disciplinary, in the, my lord, under section 9 of the Karnataka Lokayukta Act. Preliminary inquiry, it came out that he is guilty of the offense committed, assaulting grievous injury unbecoming of a public servant. That was entrusted to the Lokayukta. Under 12/4, it was sent to the government. He was working as a police sub-inspector then. He is now working as an assistant commissioner, I guess, in the commercial tax department. My lord, so R3 and R4 are police department as well as the revenue department, because he is working as a CTO or assistant commissioner in the commercial tax department. My lord, thereafter, when the inquiry started before the Honorable Upaloka ARE 4, my lord.
You said a 12/3 report was submitted.
My lord, 12, yes.
Then what happened?
12/3 report is at.
Then what happened? ಆಮೇಲೆ ಏನಾಯ್ತು?
Government ಗೆ ಕಳಿಸಿದ್ರು. So therefore, government entrusted the inquiry, disciplinary inquiry, to the Lokayukta itself.
Under Rule 14 capital A.
Yeah. My lord, thereafter, it was assigned to Honorable ARE 4.
Registrar ಏನ್ ಮಾಡಿದ್ರು?
My lord.
What registrar did in the inquiry?
My lord, it is at.
Found guilty, na?
No.
Was he found guilty?
No.
Not guilty.
My lord, thereafter issuance of charges, article of charges were framed.
All right, ಮುಂದೆ ಏನಾಯ್ತು? ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ಏನಾಯ್ತು?
My lord, I appeared before the disciplinary.
All right, enquiry report ಏನಾಯ್ತು?
ಇಲ್ಲ ಆಗಿಲ್ಲ. In the meanwhile, he came here before he filed an application under section 19 before KAT Bangalore.
Challenging inquiry.
Yes. Before the completion of the inquiry, he filed an application to quash both the orders passed by the government as well as the issuance of charges, article of charges. My lord, prior to, after the article of charges were framed, I was given notice and I submitted more than 35 documents in my favor. They were marked. Only then that he came to know that there'll be an order against him. So he ran to the KAT on 31, on 1/12/2016, my lord. My lord,
ಒಂದ್ ನಿಮಿಷ ರೀ. ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ 12/3 ರಿಪೋರ್ಟ್ ಬಂತನಲ್ಲಿ 12/3 ರಿಪೋರ್ಟ್ ಡೇಟ್ ಏನ?
12/3 report.
12/3 ರಿಪೋರ್ಟ್ ಡೇಟ್ ಹೇಳಿ.
Which is on
12/12/2014.
The entrustment order was passed on 24/3/2015.
What we are asking?
I'll correct.
What you are saying? What's our question?
12/3 was, when was the 12/3 order was passed?
Where is that? Answer that question.
Please,
Don't waste our time.
Please, please.
What is the date of 12/3 order? 12/3 report.
My lord, I have attached it.
Answer the question.
Please.
Annexure R.
Do not know. Answer the question.
12/12/2014.
14A entrustment order is?
Not
24/3.
On 24.
23/3/2015 or 24/3/2015.
Charges were framed, Lords,
12/5/2015.
article of charges.
Article of charges dated
12/5/2015.
12/4.
12/5.
12th May.
Then inquiry was completed on which date?
This inquiry was not completed.
That was called
Because in
in.
the meanwhile, he went to KAT and led a challenge to that one.
That too after more than 1.5 years.
On what ground KAT has given relief to him?
1/12/2016, he
Alright.
filed an application before KAT.
On what ground KAT has set aside all
Which is-
that? ನೀವು ಒಂದು ಹಾಕಿ ನಿಮ್ದು ಇದೆನಾ? ನಿಮ್ದು ಇದೆ.
That I have filed a false complaint.
On what ground KAT has set aside the order?
My lord,
Order is set aside on what ground?
my lord, KAT has done the investigation, which is the domain of the police,
Where is
which
that?
has gone into the correctness of the article of charges. It is not authorized to do so as per Honorable High Court and Supreme Court judgment.
Who went to that SC/ST commission?
My lord, me, myself, I belong to SC/ST community.
What happened in commission?
My lord, it is still pending. He has stalled all the enquiries and investigation. He has never, the police never investigated. They did not register FIR, but the private complaint is alive. SC/ST commission, there is no, he has made false submission before the KAT that he has received a favorable order, which is utterly false. And at Annexure W in my petition,
You have lodged a police complaint, you have lodged complaint before the SC/ST commission, you have lodged complaint before the Lokayukta.
Yes.
In how many forums you want to harass that officer?
my lord, criminal proceedings as well as disciplinary proceedings, they go in parallel.
They are different.
Yes, they are detached. They can go parallel according to many judgment. starting with Captain Paul judgment. I have not filed any false complaint, my lord. Till date, he has managed to, even before this honorable court, he has delayed the matter. And learned additional advocate general was appearing for him prior to being appointed as advocate general.
ಅವ್ರ choice ಬಿಡಿ ನೀವು ಬೇಕು ಅಂತ ಇಟ್ಕೊಳ್ಳಿ.
My lord,
No, everything is parallel proceeding can go on is your first submission.
my lord, I am submitting my My lord, firstly, KAT cannot go into the correctness or set aside the article of charges in the first place. It cannot even stay the proceedings as per Honorable Supreme Court judgment. My lord, shall I read out the?
Come to page 39, running page 39. He's a private party, don't worry about him. You come to page 39, running page 39. Please. In all these proceedings, the applicant is exonerated by considering under the provisions of Police Act and Police Manual antideyala. Yav proceedings?
Millards, when Millards, the incident Millards which was taken place on particular date, after that Millards, he approached the higher authority, wherein Millards inquiry was conducted, and Millards, he was Millards heard at that time, and Millards report was submitted to the competent authority saying that Millards, the charges are not proved. And after that Millards, he went to the Millards Commissioner of Social Welfare and files a petition before the Social Welfare. In turn, Millards Social Welfare Minister has directed the concerned Millards ACP, who is higher than the one report which was already submitted. Once again, Millards inquiry has to initiate.
12 report ideyala.
What Millards I would like to.
Twelve-3 report ಏನ್ ಹೇಳ್ತು?
Millards 12-3 report Millards I have Millards after the Millards 12-3 Millards the 12 Millards
What 12-3 report said?
Millards because I have Millards
You're not answered. You don't want to answer.
no Millards Millards my
It said
12-3 is Millards not a part of Millards my because I have challenged the Millards entrustment itself and Millards subsequent framing of Millards articles of charges. Millards I am not on the Millards 12-3 report. Millards my
ಈಗ ಅದು 14A
please
is quashed by the court. Correct?
Please.
Quash ಆದ್ಮೇಲೆ matter goes back to 12-3.
12-3. As my lord, Millards
We have already held that way now. Because the latest judgment.
Recent judgment of.
ಅದಾದ್ಮೇಲೆ government ಏನ್ ಮಾಡುತ್ತೆ?
Since government Millards the Lokayukt had also Millards challenged the order of Millards quashing. Now it is pending consideration. May I take my lords to the Millards? Now the question is, Millards, since this court had Millards already Millards, when the application for the impleading was Millards allowed, wherein his application was allowed, Millards detailed order Millards came to be passed by this honorable court, which is at Millards the
Holding?
order, Millards and Millards holding that Millards the application which was filed by is not maintainable because I have Millards placed the all the material.
Anyway, ಬಿಡಿ ಅವ್ರದ್ದು ಮೇಂಟೈನ್ ಆಗೋದು ಬೇಡ. ಅಲ್ಲಿ ಲೋಕಾಯುಕ್ತ ಇದಾರಲ್ಲ ಮುಂದೆ.
ಅವ್ರದ್ದು ಅಷ್ಟೇ.
Even if we ignore his petition, Lokayukta is before the court now.
That's my specific contention to your lordship is that when Millards two competent authority, when I was working as Millards police inspector, police sub inspector, the competent authority, the higher authority, they have conducted the Millards inquiry and submitted a report. And subsequently also Millards one more inquiry Millards was ordered at the instance at the directions of the Millards the social welfare department, wherein also Millards the case was Millards considered and Millards whatever the charges alleged against me were Millards not proved. In spite of that Millards same was brought to the notice when Millards I got selected to the Millards KPSC through Millards gazetted probationary. Millards I got Millards selected. Millards did not stop it. Millards he went Millards after that Millards filed a Millards complaint before the Millards Lokayukt. And Millards I have taken
Found him guilty.
Yes, yes,
ಮತ್ತೆ ಅದನ್ನ ಈಗ ಲೋಕಾಯುಕ್ತ is a high court judge, retired high court judge, correct?
Please.
Your departmental is domestic level inquiry.
Inquiry was conducted, my lords, and charges were not proved.
Now there
Those
is
are the, my lords, part of the, my lords, application which was filed before the KIT. After considering those, my lords, material, my lords, the court comes to conclusion that, my lords, the article of charges which were, my lords, issued against me were, my lords, quashed.
It is there quashed, 14A is also quashed. Then it is relegated to 12.3. Latest
Judgment of your lords.
12.3 prakara bidi, we will ignore him. What about Lokayukta?
For that, my lord, I'll argue on that, because, my lords, my request was, since, my lord, he cannot contend that he cannot be heard.
All right, we will leave him. But there is Lokayukta also. Lokayukta, after inquiring all these things, it found his allegation to be true. There is a,
please.
There is a report now, 12.2, 12.3 report is there. 14A ಮತ್ತು articles of charge ಕುತ್ಕೊಳ್ಳಿ. Your presence creates problem too. 12.2, 12.3 ಇದೆ. Now it is relegated to 12.3. What the government has done. ಅದು crash ಆದ್ಮೇಲೆ. Now they have quashed the report also. Yes. Report is also quashed. Therefore you are challenging it.
Yes. They quashed 14A and also, my lord, article of charges.
That
consequential.
Consequential.
Only judicial member quashed the report of the Lokayukta.
Initially, my lords, there was single member who sat, my lords, more than, my lords.
What is that judgment apex court said where Lokayukta report is challenged, at least 2 judges should sit together.
ನಮ್ದೇ ಒಂದು ಬೆಳಗಾವಿ ಇದು ಗುಲ್ಬರ್ಗದಲ್ಲಿ ಮುಚ್ಚಂಡಿ ಅಂತ ಮಾಡಬಹುದು ಅಂತ ಏನೋ
ಮಾಡಬಹುದು ಅಂತಿದೆ.
ಅಲ್ಲಿನ ಸೇಮ್ ಕಂಟೆನ್ಷನ್ ಆಗ್ತಿದೆ ಅವಟೇಕ್.
No, 14 capital A, yes. But quashing report of the Lokayukta.
Report ಅದು ಕ್ವಾಶ್ ಆಗಿಲ್ಲ.
Report quash ಆಗಿಲ್ಲ. Then it goes back to, if report is not quashed, 12.3 is not.
14A.
Then it goes back to government. Yes, that is the law we have declared now. Party may not be aware of, don't worry, he is not a lawyer. But you are aware now, you have argued that matter.
Please.
What the government is going to do? Now it is relegated to the 12.3. Within 6 months you have to take a decision and hold madeo now. Proceedings are not end of the matter.
No, not here. Pursuant to Lokayukta 12.3 report, I have taken a decision already.
What decision you have taken?
Interesting.
14A.
Interesting inquiry.
That goes now.
Now that was not.
But report revives because of our judgment.
If I have not taken, my lord, then once again, my lord, I have to the
You have
next
to
step.
reconsider.
No, the only, my lord.
Why can't you read that paragraph?
Merit. For the contention of the respondent employee that the Lokayukta has no locus standi in a matter like this is bit difficult to counter. Firstly, the tribunal has faltered the action on the ground that section 9.3 of the 1984 Act has not been complied with by the Lokayukta. Secondly, the article of charges have not been properly formed. Both these actions apparently fall within the domain of Lokayukta as an institution. Thirdly, the Lokayukta was a party nomino to the proceedings before the tribunal, and it had made all endeavors to justify its action by pointing out that section 9.3 was duly complied with. Fourthly, if at all there is a violation of said provision, the matter ought to have been remitted back to the stage of violation for consideration appraised.
Correct.
And despite that having not been done, the government has not chosen to challenge the tribunal order. Inaction on the part of the government competent authority would infuse additional elements of locus standi in favor of the Lokayukta. An argument to the contrary to the above view, if accepted, would leave a wrong order of the tribunal with impunity forever, and the employee who has been found guilty of misconduct would go scot-free. That would not augur will be to the rule of law, which requires protection of the innocent and punishing the guilty. Otherwise, the interest of administration would be badly affected. Added to the Lokayukta, is not a busybody. It is established as a statutory entity for playing a pivotal role in the prevention of maladministration. In function as watchdog of the public administration in welfare state as ordered by the Constitution of India. It is not that in every case wherein a relief is accorded to public servant as a matter of course, the Lokayukta will have the locus standi. It all depends upon the facts and circumstances of the individual case brought before the court.
Yes.
So it not
Next paragraph.
the coordinate bench, my lord has referred the L.
This is
Prakash.
Satish Sharma's judgment. Next.
No, sorry, sir. In the above being said, the observation of the coordinate bench in respect of their precedent proposition textually appear to be too broad. My lord has referred Prakash judgment, Satish Chandra judgment. No? Is true, and therefore the bar is justified in asking us to delineate the correct scope of the ratio laid down by the coordinate bench in Prakash Supra, and more particularly para 52 reproduced above. The said observation need to be construed in their true spirit and in the light of the scheme collectively emerging inter alia from the provisions of section 9 and 12 of the 1984 Act read with rule 14A of the 1957 rules. The caution needs to be taken while applying the principle of judicial precedent, since the decision of the court and its observation have to be read in context in which they appear. In a judgment, discussion is meant to be explained and not to define. A full bench of Bombay High Court, my lord has referred to Bombay High Court. The precedental value of a judgment is not derived from.
Next.
Please. Keeping the above in consideration, one can with no risk of contradiction postulate that where the tribunal
Yes.
has interfered in the delinquent employee cause inter alia on the ground that proceedings held by the Lokayukta or its delegates suffer from legal or factual infirmity, the Lokayukta will have a locus standi to knock the doors of writ court.
Correct.
It is more so when a competent authority for whatever reason does not choose us to challenge the order of the tribunal
Yes.
within a reasonable time of say 6
Because
months.
government has not challenged.
Yes, ma'am. They have
Your 14A order,
please.
you want to justify or you want to argue against 14A order?
No, no, I will justify, my lord, but the tribunal order, the honorable KT has, my lord, should not entertain the, my lord, it's a premature stage.
So you support a case of the, though not citizen, Lokayukta.
Lokayukta, I
You
support,
support that case.
Support Lokayukta. Since, my lord,
Yes.
it's in a premature stage.
Anyway, premature under what action you have taken? KT set aside ಮಾಡ್ತು.
Please.
Set aside ಮಾಡಿದ್ಮೇಲೆ ನಾವು ಈಗ ಹೇಳಿದ್ದೇವೆ.
Please.
Government ಏನ್ ಮಾಡಬೇಕು ಅನ್ನೋದನ್ನ ಹೇಳಿದ್ದೇವೆ. Next week ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬೇಕು ನಮಗೆ. You can't sleep over the matter. Assume that he has no locus standi. Still, Lokayukta has got locus standi. Matter stands relegated to the level of government. 14 states, 14A states.
No, 14, my lord, it's like.
That has gone now.
It's not, my lord, if you see the order, my lord.
You want to justify KT order or you want to argue against the KT order?
Against the KT order.
Against the KT order. Therefore, then you have to take action now because of this judgment.
Please.
What action you have taken? ಯಾವಾಗಾಗಿದೆ ಆರ್ಡರ್ ಇದು? May 2020. Now already take that because of this judgment. Take action in terms of that Lokayukta report. Why he will falsely say he is pursuing so many forum because he is aggrieved.
Please.
And the Lokayukta has found his allegation true. How can that be curtailed by the KT by single judge? How can a single judge of the administrative tribunal find a fault, and he has not found a fault with the Lokayukta report at all? If that is so, report remains intact.
Please.
Because of our judgment, because of the Honorable Justice Satish Sharma's judgment. Take action in terms of that. Till next week, you have to tell us what action you have taken against the concerned officer. ಅವ್ರು ಹೇಳಿ ನಿಮ್ಗೆ ಲೋಕಸ್ ಇಲ್ಲ, ನೀವು ಇರೋದು ಬೇಡ, ಬಟ್ ಹಾಗೆ ಇರಲಿ, ಅವ್ರು ಇರ್ತಾರೆ, ಅವ್ರಿಗೆ ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡ ಇದೆ, ನಿಮ್ಗೆ ಇಲ್ಲ.
ಮೇಡಮ್, ಇದು ಡಿಲೇ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
ಡಿಲೇ ಆಗ್ತದೆ ಯಾವಾಗ ಆಗ್ತದೆ. ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ಆಗಿದೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಅಷ್ಟು ಅರ್ಜೆನ್ಸಿ ಅಂತದಿಲ್ಲ. 2013 ಏನೂ ಆಗಿಲ್ಲ, ಹೌದಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅನ್ನುವಂಥದ್ದು ಏನು ಮುಗಿಲ್ ಬೀಳ್ತಾ ಇದೆಯಾ? ಕರ್ಕೊಂಡು
ಇಲ್ಲ, ಬೆಂಚ್ ಚೇಂಜ್ ಆಗುತ್ತೆ.
ಬೆಂಚ್ ಚೇಂಜ್ ಅವರು ಜಡ್ಜಸ್, ಎಲ್ಲರೂ ಜಡ್ಜಸ್ಸೇ. ವಾರಂಟ್ ಆಫ್ ದಿ ಪ್ರೆಸಿಡೆಂಟ್, ವಾರಂಟ್. ನಾವು ಮಾತಾಡೋದು ನೋಡಿ ನಮ್ಮ ಮೇಲೆ 3.
ಇವತ್ತು ಕೈಂಡ್ಲಿ ಅಬ್ಸರ್ವ್ ವಾಟ್ ವಾಸ್
call immediately after vacation. In the meanwhile, the government has to state as to what is being done post KAT order in view of our judgment in
WP number 105477 of 20.
ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ
ಇನ್ನೂ ಆಗಿಲ್ಲ.
ರಿಪೋರ್ಟ್ ಮಾಡಿಸಿ
ಅಲ್ಲ ರಿಪೋರ್ಟೆಡ್ ಆಗಿದೆ ಬಟ್ ಇನ್ನು ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಬಟ್ ಇನ್ನು ಇದರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ
ರಿಪೋರ್ಟೇಬಲ್ ಆಗಿದೆ
ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲ. ಆಗಿಲ್ಲ ಸ್ವಲ್ಪ
ಇದ್ರ ಪ್ರಕಾರ ಏನಾಗಿದೆ ಅಂತ ಹೇಳ್ಬೇಕು ನಮಗೆ.
ಪ್ಲೀಸ್.
ಈಗ ವೈ ಸಿಟಿಸನ್ ವಿಲ್ ಫಾಲ್ಸ್ಲಿ ಮೇಕ್ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ an officer because he is aggrieved and his allegation is found true by the lokayukta. Maybe that he should not have gone to private complaint, etc. Now he is answering, parallel proceedings can go on. Anyway, we can consider all that. How can KAT say his version is false when that to single member? When lokayukta says no, what he said is true. Next date ಹೇಳ್ಬೇಕು.
Lord, idu exchange, I mean, mine is the main case of 461, my lord.